Thank you very much once again. It's me, Ekens, the founder of Ekens Foundation International, helping rejected refugees and asylum seekers in various detention. Today, I want to draw the attention of all the Canadian members of parliament of these particular facts when it comes to immigration, and to talk about the roles of the prosecutory state in refugee and asylum process in relation to issue of confidentiality in asylum procedure. The question is, who are agents of persecution and who are refugees aggressors? What is the distinction between the country of persecution and the country of protection when it comes to refugee application? What are the obligations of the country involved under the Geneva Convention, the 1951 Geneva Convention, and the protocols? The fact is, when someone leaves his or her country of origin to another country for reason of seeking refuge or asylum, or as soon as someone filed an application for refugee or asylum, automatically the person country of origin become the persecutory state in question. However, while the police and the other security operatives become the agent of persecution, in other hand, the country where the applicant is seeking refuge become the country of protection. This is compliance with the Geneva Convention. This means the person who is seeking protection against his or her country of origin or the persecution under the Geneva Convention. However, I want you to understand or to bear in mind that the United Nations High Commission for Refugees, which is the body that have direct interest in applications under the 1951 Geneva Convention relating to the status of refugee, while the UNHCR in question has a duty to supervise all applications under the provisions of the Geneva Convention for the advisory opinion relates to the principle and which applies for the member states. It is very important to understand that the international human rights law guarantees everyone's right to privacy and the protection of individual of any arbitrary law or interference. But my main question here is if the United Nations High Commission for Refugees are meeting the obligation or have they been influenced by the host country. This question should be answered by the Inspector General of UNHCR because the general principle governing the confidentiality requires that the sharing of information with the external party in refugee determination should not jeopardize the safety of the individual concerned or lead to the violation of his or her rights. This is in compliance with the Article 17 of the International Covenant on Civil and Political Rights, ICCPR. My point here is, it is illegal for a country of protection to seek for an opinion of country of persecution in determination of refugee application. Here are my points. Why Canada should respect this international law in determination of refugee. The Canada Border Service Agency, CBSA, is doing opposite. The evidence shows that the Integrity Department of Canada Border Service Agency, or the CBSA, often violate this rule. Therefore, I am calling on the Canadian Prime Minister, Justin Trudeau, to mandate the Minister of Immigration and the Minister of Public and Safety, also as well as the Minister of Foreign Affairs, to investigate this international violation by the immigration officials because they are creating bad image to the country. This would stop them from acting on impunity on their files they are handling. Those officers are to cause harm to central government because they are working on conservative ideology. Thank you very much once again. My name is Ekens. You can subscribe by our YouTube. You can details of ekensfoundation.com.